Nagbabalik tayo dito sa Kababayan Today. We are live in Los Angeles. If you are watching us in Hawaii, unfortunately, we cannot take your calls, but we are talking about something very important. We have someone on the phone with us, si John from Van Nuys. But before we talk to him, we just want to wrap this up. It's very important about the Filipino World War II veteran policy, parole policy rather. I have a question that's really pertinent to the situation. A lot of them have passed away just because of how long it's been. What about them, the families of the petitioners that have passed away? Are they still eligible?
Yes, in some circumstances, as Ali was saying earlier, if the veteran passed away here in the United States, then the beneficiary could basically self-apply for parole outside of the United States to come back in. And so it is possible, but first they have to reinstate the petition, because petitions are automatically denied when the petitioner dies, so they have to apply for reinstatement of the petition, then apply for parole.
Okay, so for those that are granted parole, Ali, what does it allow them to do, and for how long will they be granted the benefits of the parole?
Yes, so after the processing time, which as Richard pointed out is about 6 months, if they are granted parole, it will allow the beneficiary and any derivative beneficiaries who have submitted their own separate applications, so the spouse and or unmarried children under age 21. For those granted parole, it allows them to enter the United States. When they get here to the United States, they will go ahead and be granted authorization to be here in the U.S. as a parolee for a period of 3 years. After they've entered the U.S., they can go ahead and apply for a work permit. The work permit, as generally is, it takes about 90 days to obtain. They can get the work permit, presumably at this point, for the period of 3 years that they've been granted the parole visa. As far as traveling in and out of the United States during that parole period, you would first have to apply for a separate document known as advance parole.
Right.
But as long as you're granted the advance parole, then you can travel during that parole period. Presumably, during that 3-year period of time, they'll get to your place on the waiting list, they'll get to your priority date, so that you can then apply from being a parolee to your green card through the adjustment of status process. If your priority date is not yet current, you should be eligible to extend up until the time you become eligible for the green card.
Okay, so it's safe to say that this can serve as a way to get your citizenship in the long run.
Eventually.
Eventually. Okay,
Yes.
this is wonderful. Mga kababayan, make sure to look that up. That is the Filipino World War II veteran parole policy. And now, kasama natin from Van Nuys, kasama natin si John. John, nandiyan ka ba?
Yes, I'm here.
Hi, what is your question today?
Hi, good afternoon, Paul. My question is, my wife is sponsoring both of her parents, and she has 2 half-sisters with the father. Now, the older sister is going to be 22 in December, but the younger one is about 19. Are there any chance of both of them being able to come with my in-laws or not?
So in this situation, when a U.S. citizen child is petitioning a parent, they fall under a category known as immediate relatives. And under the immediate relative category, unfortunately, there is no ability to have dependents or derivatives as a part of that petition process. And so, in other words, unfortunately, even though the kids are still under 21, they cannot get a visa at the same time as the parent. The only thing that can be done is either once the parent, what should be done is once the parent obtains the green card or obtains the immigrant visa, enters the United States, at that point in time, the parent really should immediately file the relative petition for the children, and that's going to have to be the process for the green cards for the kids.
Okay. All right. There you have it. If you are in Los Angeles, please give us a call. Our phone number is 1-800-553-5724. We are taking your calls here in Los Angeles. And before we started taking your calls, we were talking about the Filipino World War veteran parole policy. Okay? Now we have our next caller on the phone. Kasama natin si Josie. Josie, nandyan ka ba?
Opo, andito po ako.
Hi, Josie. Taga saan po kayo?
Andito ako sa Van Nuys. Thank you naman at paundakan mo ko.
Oo. So, Josie, ano po yung tanong ninyo para sa ating mga lawyer na nandito ngayong araw na ito tungkol sa immigration?
ang tatanong ko lang kasi, yung asawa ko, petitioner ako. Ang asawa ko ay 6 na taon na rito sa Amerika. Eh, meron akong sulat na galing sa immigration. Ay, yung sulat na yun na extension for green card niya ng 3 taon. Eh, hanggang ngayon, hindi pa dumarap yung for 10 years green card. Ano ang dapat kong gawin?
Okay, so she's asking what she needs to do. She's been waiting for that green card, I guess, for 6 years now. Was that the question?
I wasn't quite certain. I believe that she had applied and gotten a temporary green card, and then she submitted the application to change it from the temporary or conditional green card to the 10-year permanent green card. In any event, regardless of the situation, if immigration takes too long in processing an application, you do need to be proactive. You need to contact the immigration, find out, usually through what's called an InfoPass appointment, what's going on with the application, why there's a delay. Applications these days really are not taking 3 years, so there must be some type
There must be something wrong going on in the system. Okay, we are taking your calls. We are live in Los Angeles. Call us when we return here on Kababayan Today.